Adebayo. I don't know whether
appearances. Appearances.
My Lord, with the greatest respect. My name is Ayotunde Shoderu.
Yes.
OM Sabitu appears with me for the claimant.
What's the name?
OM Sabitu, my Lord.
Okay. All right. The defendants, are they here?
Yes, my Lord.
Okay. Announce your appearance, please.
Respectfully, my Lord. Oluwatosin Kehinde for the defendants.
Okay. So this is the judgment between Edshaw Mobalaji Peter and Commit Nigeria Limited and one other. By a general form of complaint and statement of fact, the claimant instituted this suit on the 6th of January 2020. The reliefs he is seeking are one, another that the defendant paid the claimant the sum of 2,233,847.72 kobo, being payment of his outstanding arrears of salaries, site allowances, leave allowances, and deducted unremitted pension owed him by the defendant from the year 2015 to 2018, which is broken down into the following. 1, 453,378 naira as the outstanding arrears of salaries, 1,122,916.67 as the outstanding arrears of leave allowance, 572,553.05 kobo as the outstanding arrears of pension, and 110,000 as the outstanding arrears of site allowance owed him by the defendant from the year 2015 to 2018. The second relief is an order that the defendant pay the claimant interest accrued on all the monies owed the claimant by the defendant since the year 2018 till judgment is given at the rate of 21%, and thereafter till final liquidation of the judgment sum. The third relief is the cost of this suit. The claimant's case is that he was in the employment of the first defendant in 2015. His appointment letter was under the hand of the second defendant, who is the executive director, admin/company secretary, dated January 23, 2015. He was deployed to a project, in quote, residencies as a project manager for the installation of central heating, ventilation, and air conditioning system and central LPG system, and the project lasted till 2016 when it was commissioned. Claimant maintained that he managed the facility for another 15 months while still working on other projects remotely or from the head office. Furthermore, he combined his role as a site engineer with project manager, project engineer, design engineer, store manager, quality control, admin officer, etc., because the officers had all resigned prior to his appointment. So in order not to damage his professional career, he made sacrifices to ensure the project succeeded. His complaints include the fact that he could not go on leave for 3 years. He was owed salary for several months. His deducted pension was not remitted to his PFA, and all efforts to resolve the anomaly yielded no result. Claimant resigned on the 13th of March 2018. The claimant solicitor thereafter wrote a demand letter dated 30th of July 2018. The letter was not responded to. Upon being served with the originating processes, the defendants on 18 February 2022 paid the sum of 357,911 naira in 11 kobo into the claimant's first bank account, which was 4 years after he stopped working. The claimant claims the defendants are still in arrears of salaries, leave allowance, site allowance, and pension deductions in the sum of 2,233,847.72 kobo. During trial, 10 numbered exhibits were tendered through the claimant, who was the only witness, and they were marked as exhibits C1 to C10. They are all listed in the body of the judgment. Now, the claimant's case. The claimant confirmed that the claimant was a former employee of the first defendant who was employed as a mechanical engineer via an employment contract contained in Exhibit 1. The defendant denied the fact that the claimant single-handedly managed the project named the Residency for 15 months while working on other projects remotely or from the head office, because after the commission, because after the commissioning of the project and before the management of the facility, there was a defect liability and there was no activity on the project. On the issue of the claimant performing a combination of job schedule, the defendant denied this and stated that the claimant was employed as a mechanical engineer and assigned the duty of site manager. Other roles were handled by subcontractors under the supervision of the claimant. That since the letter of employment did not provide for leave allowance and site allowance, the claimant is not entitled to both leave and site allowance. As for pension, defendant maintained that all remittances were made to claimant's PFA, that the payee tax of the claimant was also remitted to the Lagos state government. On salary, the defendant maintained that salary was to be paid through income generated from the maintenance of the residences. Due to the nonchalant attitude to his assignment, the clients, that is, the residences, did not pay the claimant his salary. As a result, claimant was not paid his salary. That the claimant failed to comply with the defendant's directive to report at the head office twice a week. The defendant had to deduct days claimant did not report to work. And as for the salary for February 2018, it was not paid because claimant failed to give the required 1 month notice nor payment in lieu of notice. The defendant opened their case on Wednesday, the 19th of June 2024, and called one Mr. Taiwo Adepoju as their witness, through whom Exhibit D1 to D4 were tendered in evidence. I have the exhibit all listed in the body of the judgment. One Ms. Adebusola Ajayi Bende, an IBTC account officer, was issued a subpoena and she tendered Exhibit SW1, first defendant pension remittance, which was the first defendant's pension remittances to the claimant's pension account. I have the defendant's final written address here in the body of the judgment and also the claimant's final written address here. I'm going straight to, and the defendant's reply on points of law. So I'll go straight to the court decision. Okay, so I have carefully looked at the originating processes and have considered the submissions of counsel and authorities relied on. In the final written address, the Learned Defense Counsel raised an issue whether the second defendant, who is not a party to the contract of employment, can be sued. Learned Defense Counsel argued that since the claimant's relief sought are based on an employment contract between the claimant and the first defendant, all the actions of the second defendant were merely in pursuance of his official capacity as the MD. Liability in such instances attaches to the company, not the individual director acting in his official capacity. In paragraph 4.0.16, he submitted that the second defendant is not a necessary party. He was at best a disclosed principal and his name ought to be struck out from the suit. The claimant, on the other hand, agreed that the defendant's argument but submitted that the second defendant had been in the forefront of interaction. He acted as an intermediary and also acted outside his designation by responding to mails meant for the HR department or other department. Furthermore, the second defendant was duly represented throughout the trial. His objection was therefore late. Generally, it is tried that whether or not a party should be joined in a suit is dependent on whether his participation in the suit is necessary or whether it is desirable. See Green versus Green, citation provided, and Ogunsoye versus Orojojoye, citations are all provided in the body of the judgment. In the instant case, the first defendant was described in paragraph 1 of the statement of fact as, and I quote, a legal entity / company registered under the relevant laws of the federal government of Nigeria, in bracket, comma, running its business as an engineering company with its registered office in Lagos State within the jurisdiction of this court, end of quotation. The second defendant was also described in paragraph 3 of the statement of fact as, and I quote, an engineer by profession, a citizen of the Federal Republic of Nigeria, and is the chairman / MD, in bracket, alter ego, of the first defendant in this suit, end of quotation. The defendant, in his statement of fact, paragraph 3, admitted that, and I quote, the defendant admits paragraph 3, paragraph 2, 3, and 4 of the claimant's statement of fact, end of quotation. It is strike law that facts admitted need no further proof. Now, while the relief sought by the claimant are based on the workplace operations controlled by the first and second defendant, the question is whether the second defendant, as chairman / MD, is it directly involved with the operations of the first defendant, therefore qualified as a necessary party? Learned Defense Counsel, in its final written address, admitted that the second defendant was a disclosed principal / agent. Therefore, his acts are attributable to the first defendant and cannot rise and cannot give rise to personal liability. By the provisions of Order 13, Rule 14, Sub 1, and Order 13, Rule 4, 6, and 7, which makes provisions on joinder of any person as a defender, it states as follows. Any person may be joined as a defendant against whom the right to any relief is alleged to exist, whether jointly, severally, or in the alternative. Judgment may be given against one or more of the defendants as may be found to be liable according to their respective liabilities without any amendment. 6 Sub 1 provides, it shall not be necessary for every defendant to be interested in all the relief prayed for or as to every cause of action included in any proceedings against such a defendant. 6 Sub 2 goes further. A judge, upon considering the defense filed by any respondent/defendant, may, on application by that defendant, make such order as may appear just to prevent the respondent/defendant from being embarrassed or put to expense by being required to attend any proceedings in which the respondent/defendant may have no interest. 7. A claimant may, at the claimant's option, join as parties to the same action all or any of the persons severally or jointly and severally liable on any reliefs in the matter. See also Federal Government of Nigeria versus Shobu Limited, citation provided, and I quote, no proceeding shall be defeated by reason of misjoinder or non-joinder of parties, and a judge may deal with the matter in controversy as far as regards the rights and interests of the parties actually before the court. End of quotation. I'm therefore inclined to disagree with the submission of Learned Defense Counsel that the claimant's pleadings, as presently constituted, do not disclose the reasonable cause of action directly against the second defendant in terms of substantive liability. It is my view that the second defendant is properly joined as a nominal party to this suit. This is in line with the provisions of Order 13, Rule 4 of the NICN Rules 2017, which allows for the joinder of any person against whom the right to any relief is alleged to exist. Given the fact that the second defendant acted in his official capacity within the first defendant's organization, and that the claimant seeks reliefs that may or may not potentially affect the interests of the second defendant, its continued presence in this suit, albeit in a nominal capacity, is justified for the proper and effective adjudication of the matter. With regards to who is a nominal party, in Federal Government of Nigeria versus Dairy citation provided, the court held a nominal party is a party to an action who has no control over it and no financial interest in its outcome, especially a party who has some immaterial interest in the subject matter of the suit and who will not be affected by any judgment, but who is nonetheless joined in the suit to avoid procedural defects. In Onak Gorua versus IGP citation also provided, the court also held that in law, nominal defendants are not condemnable in damages, since damages follow the cause. There is no cause. Where there is no cause, there will be no damages. Furthermore, in line with the above cited cases and relying on Order 13, Rule 7 of the NICN Rules 2017, the second defendant can remain as a party in this suit, as it cannot be said that it was embarrassed or prejudiced by its continued participation in the suit, as the second defendant is a representative of the first defendant. The Supreme Court in Aya Koya versus Olukoya citation provided per Adio JSC held that a party alleging misjoinder is to act timelessly. In the instant case, the second defendant was represented throughout this matter and never raised any objection. Retaining the second defendant in this suit as a nominal party serves the purpose of ensuring a complete, just, and robust adjudication of this matter. Therefore, the objection to strike out the name of the second defendant is overruled. I so hold. Secondly, both counsel addressed the court on the admissibility of the C6 and C7. While the defendant in paragraph 4.1 argued that firstly, the two exhibits should be struck out because Moses Bambi was an agreed former staff of the first defendant and by implication he qualifies as an interested party. Secondly, the two exhibits were manufactured after the suit was instituted. And thirdly, the claimant in his statement stated that the source of the information was from one Francis M. Ezekiel, who was not called as a witness. In other words, the exhibit constitutes hearsay by virtue of Section 37 of the Evidence Act. The claimant counsel, on the other hand, maintained that the defendants were misguided with the facts, that they said Moses Bambi is a counsel handling this brief, and the exhibit were forwarded on the 24th of January 2022 to the said Moses Bambi in preparation of the case, so he could not be an interested party. The reason the counsel could not be produced in court as a witness because he was out of jurisdiction and could have occasioned further delay in the matter. That Exhibit C7 is dated 8 November 2017, and the conversation was between the claimant and Engineer Adeyemo, who is the second defendant. The court took a cursory look at Exhibit C16 and realized that indeed it is an email from Peter Osho at yahoo.co.uk to moses.bambi1@gmail.com on the 24th of January 2022 at 18:48 p.m. It was an email message from one Ezekiel Francis, Mayor Francis at yahoo.com, who is an ex-staff of the first defendant, to Peter Osho at yahoo.co.uk, the claimant in this case, giving reasons why he resigned from Commit, the first defendant, and his email was exchanged on the 24th of January 2022 at 5:42 p.m. It is clear to the court that this email exchange took place on the 24th of January 2022, while the case was pending. The court held in Olumo versus Ape, citation provided, that Section 83 sub 2 of the evidence as is anchored on the doctrine of lis pendens, which prevents the admission of documents made pendent light. In other words, documents made during the pendency of an action for the purpose of the action, and particularly after pleadings have been filed, should not be admitted on the grounds that they lack evidential value and would tantamount to stealing a match against an opponent. In the case cited, the survey plan tendered by the appellant was prepared during the pendency of the matter. The appellate court held that the trial court was therefore right in rejecting the survey plan. See also Ugidi versus Egba, Abdullahi versus Hashidu, WDN Limited versus Oyibu, citations all provided. So in the light of the above reason, Exhibit C6 is inadmissible. I so find and hold. Exhibit C7, on the other hand, are two email messages embedded in one. The claimant sent this email to moses.bambi@gmail.com on the 24th of January 2022 at 15:53 p.m. and attached and forwarded the email messages written on the 8th of November 2017 at 18:53 GMT +1 between Engineer Adeyemo, the second defendant, and the claimant. The response of the claimant was also attached and sent same day, 8th of November 2017 at 12:23. These two attachments were made before the suit was instituted and is therefore admissible. I so hold. Having dealt with the above issues, this court will now look at the reliefs of the claimant as sought in his amended statement of fact. The court will deal with the relief sought seriatim. The first relief is for an order that the defendant pay the claimant the sum of 2,232.847.72 kobo, being payment of his outstanding arrears of salaries, site allowances, leave allowances, and deducted unremitted pension owed him by the defendant from the year 2015 to 2017, which is broken down into the following. Part A is for 452,000 naira, 453,378 naira as the outstanding arrears of salaries. Parties are in agreement that there was an employment relationship between them, evidenced by Exhibit C1. Claimant is before this court seeking for 453,378 naira as the outstanding arrears of salaries. These amounts represent the balance from a total of 811,284,011 kobo, which the claimant claims was owed him. The claimant has stated that the total of 357.7911 was paid into his account on the 18th of February 2022, 2 years after the suit was instituted and 4 years after claimant resigned from the defendant company. The court noted that this statement was never disproved by the defendant. Indeed, the defendant exhibited the payslip as evidence, which was marked as Exhibit D4. In fact, this payment prompted the claimant to amend his statement of fact to reflect the supposedly correct amount being owed, and there was no objection by the defendant. By a simple arithmetic, if claimant alleged that 811,289,000 was owed and later 357,911 was paid, then the outstanding would be 453,378 naira. In an attempt to prove his claim, the claimant pleaded these facts in his statement of fact and tendered Exhibit C1, which is the bedrock of his employment relationship. It provides thus under Article A, and I quote, remuneration. Your salary package is 4,200,000 naira per annum. in bracket, all inclusive of the company salary grade 13, end of quotation. In paragraph 12 of his amended statement of fact, he pleaded that he was owed arrears of salaries, leave allowances, site allowances, and unremitted pension. Also in paragraph 18 of his reply to the amended statement of defense, the claimant reiterated that the defendant had the attitude of owing salaries. This was what prompted his email dated 8 November 2017, stating his displeasure about non-payment of his salary and other entitlement, say Exhibit C2. This was the same reason he penned down as the basis for his resignation in Exhibit C3. The court noted that in the amendment statement of defense, the defendant in paragraphs 13, 14, 15, and 16 denied, and I quote, paragraph 11 and 12 of the statement of fact, end of quotation, and rebutted the claims for leave allowance, site allowance, pension remittance, and payee remittances. In paragraph 17, the defendant stated that the first defendant is not indebted to the claimant in any sum for any service rendered, and I quote, all the salaries, end of quotation. In furtherance to his firm denial of the claim, defendant stated in paragraphs 19 to 21 that following the claimant's assignment to the residences, his salary was to be paid from the income generated from the maintenance of the said residences, and for 2 years, no extra income came into the coffers of the first defendant due to the claimant's inadequate concern and nonchalant attitude towards his assignment, to which the client in bracket the residences failed to pay the claimant's salary. In addition, the defendant averred that there was no activity on the project between when it was completed and when the management of the facility commenced. Therefore, the claimant is not entitled to salary for that period of inactivity. The court notes with dismay the defendant's reasons for not paying the claimant's salary. This is a strange term being introduced into Exhibit C1, the appointment letter. In paragraph 1, it states, and I quote, "We are pleased to offer you employment as mechanical engineer in our organization on the following main terms and conditions. A, remuneration. Your salary package is 4.2 million per annum, all inclusive on the company's salary grade 13, end of quotation." There is no provision or clause in Exhibit C1 that provides that the claimant's remuneration will be paid from revenue generated from the residences facility or any other project. Neither is there a provision that salary would be halted when there is inactivity in any project assigned to the claimant. In fact, during cross-examination, DW1 testified that the claimant was not employed by the residency project or the owner of the residency project. The defense of the defendant is an attempt to inject a foreign and a strange term into the agreed terms of the employment contract, Exhibit C1. This is an attempt to pull wool over the eyes of the court, and it will be resisted. It is tried law that parties are bound by the terms of employment, particularly where the terms are clear. CUB NPLC versus Suarez citation provided. It is common practice that salaries and wages are usually paid in arrears at the end of the month after the worker must have discharged his or her obligations under the contract. By Section 14 of the Labour Act, wages/salaries become due and payable at the end of each period for which the contract is expressed to subsist, that is daily, weekly, or at such other period as may be agreed upon, provided that where the period is more than 1 month, the wages shall become due and payable at intervals not exceeding 1 month. In the instant case, the claimant has pleaded in statement of fact, as well as stated in his resignation letter, that the reason for his resignation is as follows, and I quote, "Failure to pay me my deserved wages as at when due, while you pay others," end of quotation. From the evidence tendered, the claimant has been able to present sufficient evidence to establish that the defendant owes him salary, thereby shifting the burden of proof to the defendant. So far, parties are in agreement that the defendant, 4 years after his resignation and during the pendency of this case, after the originating processes had been served, paid a sum of 353,911.11 kobo into his first bank account, which is exhibited as Exhibit D4. In paragraph 24, sub 1, DW1 in his witness statement on oath testified that in the month of October 2017, claimant worked for only 8 days out of 22 working days. Therefore, the claimant earned 104,122 naira 67 kobo. The defendant arrived at this amount by dividing the number of days of work, that is 8 days, by 22 working days and multiplied it by the expected payment. In the month of December 2017, claimant is also alleged to have worked for 15 days, and since the month had 21 working days, the claimant earned 204,526 naira 66 kobo. In the month of March 2018, according to the defendant, the claimant worked for only 10 days and the month had 22 days. So he earned 130,153 naira 33 kobo. For the month of February 2018, the claimant was not paid. It was deducted as payment in lieu of notice of termination as provided for in the letter of employment. The court took a cautious look at the employment letter of 23rd January 2015, which is Exhibit C1, and noted that nowhere in the appointment letter was it agreed that monthly salary will be paid based on calendar days or working days. That is excluding weekdays, weekends, and holidays. What was agreed is, and I quote, your salary package is 4.2 million / annual, in bracket, all inclusive, on the company salary grade 13. End of quote. The principle of contra proferente protects the non-drafting party, which in this case is the employee / claimant. The law is tried that where there is ambiguity in a document, the court assumes that the drafter had the opportunity to clarify the terms. So the ambiguity is their responsibility and the document will be interpreted against the party that drafted it. The claimant has averred that the salary paid was calculated based on the working day model, that is, the number of days he worked and the number of working days in a month. But he failed to tender evidence of previous / current pay slips to its staff to convince the court that this was the payment model it operates as established by practice or custom in the organization. Since this model of payment was never provided for in the terms of contract Exhibit C1, besides, this court takes judicial notice of the fact that the most common model for salaried employees is the fixed salary model, where employees receive a fixed amount every month, regardless of the number of working days in a month. Example, February, which has 28 days, versus July, which has 21 days. Many a times, public holidays are declared by the Nigerian government, which applies to both public officers and workers in the private sectors. In such scenario, the defendant has failed to justify the amount so far paid by its calculation. I so find. As earlier reasoned, the claimant is entitled to a fixed salary notwithstanding the number of days in a month, or the number of working days, or the number of days he worked. In his defense, the defendant has averred that the claimant did not report for work on the days his salary was deducted. In Exhibit C1, the appointment letter, item number F provides for misconduct, and a list of offenses are itemized there to which the organization will be entitled to exercise its power of summary dismissal. The court noted that the months of October and December 2017, which the defendant maintains the claimant did not report to work, there is no evidence of a query being issued, nor an invitation to face a panel. The only exhibit tendered is an attendance register to prove he was absent from work. The defendant in paragraph 26 again stated that the claimant on the 8th of November 2017 was directed to report to the head office twice a week, that is Wednesday and Thursday, but the claimant failed to comply. The court noted that the defendant did not follow up to enforce the directive. The law is tried that an employer cannot legally deny or withhold salary for work done. Salary must be paid regardless of an employee's conduct, unless there is valid suspension without pay pending investigation or inquiry. Besides, if an employer chooses to overlook an infraction, the employee cannot be punished retroactively by docking pay. The conduct of the employer amounts to a waiver of his right to punish for the past conduct, especially if the punishment is unrelated to warrant a salary denial. The act of the defendant by denying or withholding the salary is a blatant breach of the contract, especially when the employment agreement guarantees regular pay and an unlawful deduction was made, which is not expressly permitted by law nor authorized in writing. The defendant had the option of following proper disciplinary procedures, that is warning, suspension, or termination, not by unilaterally deducting the claimant's salary. By Section 5 of the Labour Act, no employer is expressly permitted to make deduction from the salary for or in respect of fines without the written consent of the employee. It is pertinent to state at this point that salary is a legal obligation imposed on the employer and cannot be suspended due to inactivity of the employer's business. The defendant's argument that since there was inactivity between when the project was commissioned and when the defendant started managing the facility, therefore the claimant is not entitled to his pay, runs foul of the law. See Section 7 of the Labour Act and the implied duty of the claimant the implied duty of the defendant to pay salary. The defendant also, by his calculation, deducted 1 month's salary because the claimant failed to give notice of his resignation. And going by Exhibit C1, it provides, and I quote, either party initiating the termination of service will be required to give 1 month notice in writing or equivalent pay in lieu, end of quotation. In Exhibit C3, the resignation letter was dated 13th March 2018, and the resignation was with effect from the 15th day of March 2018. Parties are in agreement that claimant's salary was 350,000 monthly, and that deductions, and after deductions, it amounted to 286,337 naira 33 kobo. This court finds that the claimant is not entitled to the 1 month salary due to his failure to give notice to his employer or of his resignation. It is tried law that parties are bound by the terms of the contract of employment. See Exhibit C1, paragraph C. Relief 1 succeeds to the extent that claimant has therefore been able to establish his claim for 453,373 naira less 1 month salary as the outstanding arrears of salary I so hold. The second relief sought is for 1,133,916 naira 67 kobo as the outstanding arrears of leave allowance. The claimant has stated that he did not go on leave for 3 years due to the tight and busy work schedule. He also stated that the leave and site allowance had been paid earlier but was not sustained. In his additional witness statement on oath, paragraph 11, the claimant claimed that the leave allowance are part of his statutory entitlement. DW1, on the other hand, stated in paragraph 16 of his witness statement of oath that the defendant never had any agreement to pay leave allowance. He, however, testified during trial that the 2 allowances, that is leave and site allowances, had been paid at certain periods, but he was aware that the claimant had made, demands for the allowances. He maintained further that even if the allowances had been paid, they were voluntary gifts made to the claimant. The court noted that in Exhibit C1, annual leave was not captured as a term of the contract, and Article H states, and I quote, other terms and conditions are contained in the company's policy and procedure handbook. The court, however, noted that the company policy manual was never tendered before this court. Be that as it may, it is tried law that although the courts tend to apply strictly and give effect to the written terms and conditions of service and will usually refrain from making contracts for the parties by altering the written terms of imposing new terms on the parties, there, however, exist statutory terms and conditions of employment as provided for in sections 7 to 19 of the Labour Act. Section 7 provides for the written particulars of terms of employment, which, by the way, must be given to the worker not later than 3 months after his engagement. This section gives an overview of what the terms of a contract should be, such as the name of the employer, the nature of the employment, the duration, rates of pay, and method of payment, hours of work, holiday and leave and sick leave entitlements, notice period for termination, any applicable collective agreement. This provision provides clarity and transparency between parties. Section 7 sub 1G sub 2 of the Labour Act stipulates for these terms and conditions relating to holiday and holiday pay. As a general rule, an employee is entitled to wages during his leave. Usually, payment of salary during leave or holiday is incorporated into his contract of service. From the provisions of the Labour Act, it is clear that holiday and holiday pay is a statutory entitlement, I so find. The claimant stated that leave allowance had been paid earlier but was not sustained. This was corroborated by DW1 during trial. The claimant is claiming 350,000 naira per annum for the years 2015, 16, 17, and 2018. The claimant was employed January 23rd, 2015 and resigned on the 13th of March 2018. He is therefore seeking 250,000 per annum for the period he worked, that is 2015 to 2017, and 772,000 naira, 72,916 naira, 67 kobo for 2018. The claimant has established his entitlement to the leave allowance. The defendant confirmed during trial that claimant had made demands for the leave allowance. In the circumstance, this court is convinced that the claimant is entitled to the sum of 1.1223 916.67 kobo. This court therefore grants an order for the payment of this amount as the outstanding arrears of leave allowance. Relief 2 succeeds, I so hold. Relief 3 is for 547,553 naira 5 kobo as the outstanding arrears of pension. The claimant was employed January 23rd, 2015 and resigned on the 13th of March 2018. By the provisions of the Pension Reform Act, it is the duty of the employer to deduct and remit pensions together with the contributions of the employer. This is a statutory obligation which carries a penalty for failure to comply. By Section 11 sub 3 of the Pension Reform Act, it places a duty on an employer to deduct at source the monthly contribution of the employee and within 7 days of such deduction, remit the amount to the pension fund administrator. Section 4 also provides guidelines for such contribution, and Section 103 states that the person who does not comply with the provisions of the law has committed an offense. By Section 100 sub 2, it compels the defaulting employer to refund all the amounts not remitted or misappropriated. It is in evidence in this court, as shown on Exhibit C, 8 and C and SW1, that the defendants failed to remit the pension remittances of the claimant as at when due. The defendant, by his conduct in Exhibit C2, admitted that pensions for May 2015 was remitted in March 2016, and pension for the month of June to December 2015 was yet to be paid because management approval was pending. During trial, Stanbic IBTC pension manager gave evidence on behalf of the defendants and produced the current statement of account of the claimant's remittances. This was tendered, admitted, and marked as Exhibit SW1. A look at Exhibit SW1 indicates that the pension of the claimant was paid as follows. On the body of the judgment, I have it tabulated. So I'll just go back to continue with the judgment. The claimant, however, contends that he still has an outstanding arrears from the shortfall from the amount deducted and remitted. In paragraph 22 sub 3, the claimant added that 8% of the amount is expected to be 28,000 naira, while 10% of the employer's contribution ought to be 35,000 naira. Total contribution would therefore amount to 63,000 naira. Learned Claimant Counsel has argued in his final written address that remittances were made to IBTC later than the period stipulated in the Pension Reforms Act by Section 11 sub 2 and 3. That is, not later than 7 days from date salary is paid. Secondly, the Learned Claimant Counsel argued that from SW1, the highest amount paid was 50,400 naira instead of 63,000 naira. The court took time to scrutinize Exhibit SW1 and noted that indeed the defendant company remitted the pension contribution months and sometimes years later than is required by the Pension Reform Act 2014. And there were clear indications that from the entries that the amount was far less than what the claimant was entitled to in the circumstance. In addition to Exhibit C2, the communication dated 6th of May 2016 between the Accounts Department and the claimant also indicate an admission that remittances were not paid promptly. See paragraphs 2 and 3, and I quote. Secondly, pension for June to December 2015 is yet to receive management's approval for payment. Thirdly, please do not take the matter up with PENCOM, as the management is currently working on ensuring that liabilities are settled. End of quotation. There is therefore no doubt that remittances were delayed and the amount paid were less. The claimant is therefore entitled to 542,553 naira 5 kobo as outstanding arrears of pension. I so hold Relief 1C succeeds. In Relief 4, the claimant is seeking 110,000 as the outstanding arrears of site allowance owed him by the defendant from the year 2015 to 2018. From the statement of fact, the claimant is a qualified engineer by profession, and from his testimony and exhibits tendered, claimant had worked at the residency project as a site engineer. It is his case that earlier in his employment, site allowance had been paid. The claimant failed to tender evidence to support his pleading by way of a payslip or a statement of account. Although parties are in agreement that he had worked at the defendant's site/project and payment had been made, but it was not sustained, this court is left to speculate on the amount that was paid, which he cannot do. The claimant has not been able to prove he is entitled to this relief, that is the site allowance. It is tried law that parties are bound by the terms of the contract they have entered into. See Adams versus LSDPC, citation provided. The employment contract did not provide for this allowance, and the claimant failed to establish that by a custom of his profession and as agreed with the employer, site allowance should be paid. Even the amount that was purportedly paid earlier was never disclosed to this court. In the circumstance, relief 4 fails, I so hold. The claimant is seeking for an order that the claimant pay interest accrued on all monies owed the claimant by the defendant since the years 2018 till judgment is given at the rate of 21% and thereafter till final liquidation of the judgment sum. It was Rhodes Vivos Jesse A, as it then was, relying on Equinife versus Wayne, citation provided, Texaco versus Pedma, citation provided, Habot Plasticine Limited versus Wayne Tank and Pump Limited, citations provided, and AB Kemp Limited versus Tolan, citations all provided. Who took time out to espouse on the position of the law on the vexed issue of pre-judgment interest in the following words, and I quote, "When actions are brought on commercial matters, the court usually finds that money owed to have been paid sometimes ago. In such cases, it ought to carry interest, and that is pre-judgment interest. The time pre-judgment it would start to run depends on evidence. The basis of such an award is that the defendant had kept the plaintiff out of his money, and the defendant has had the use of it for himself, so he ought to compensate the plaintiff accordingly." End of quotation. The general rule at common law is that prejudgment interest is not payable on a debt or a loan in the absence of express agreement or some cause of dealing or custom to that effect. Thus, prejudgment interest will be payable where there is an express agreement to that effect, and such agreement may be inferred from a cause of dealing between the parties, or where an obligation to pay interest arises from the common practice or usage of a particular trade or business. See Fortune Limited versus Attorney General of the Federation and Diamond Bank versus Partnership Investment Company Limited. Citations all provided. So consequently, a claimant, in order to succeed in a claim for prejudgment interest, must show how the entitlement to such interest arose. That is, whether by law, by act, by contract or agreement, or he must plead facts showing that the claim is part of the loss or special damages which the defendant's wrong imposed on him. It is not enough to merely say that the claimant is claiming interest. The basis of the claim of interest must be made manifest on the pleadings. See again Equinife versus Wayne, Sani Abacha Foundation for Peace and Unity versus UBA, citations all provided per Abiri JCA. In the light of the foregoing authorities, it is without doubt that the claimant presented no scintilla of proof that there is either an agreement for 21% interest or statutory provision imposing the payment of the said interest on the sum awarded to the claimant as pre-judgment interest. Consequently, the claim of 21% pre-judgment interest on the judgment sum is refused and also dismissed. With regards to post-judgment interest, on the other hand, I take into cognizance the provisions of the rules of this court, which by Order 47, Rule 7, stipulates that the court may, at the time of delivering judgment or making the order, give direction as to the period within which payment is to be made, and may order interest at a rate not less than 10% per annum. This court is convinced that the claimant has succeeded in establishing that the defendant owed him salaries and over time deliberately failed and neglected to remit his pension when due as provided by the Pension Reform Act. This action has undoubtedly caused the claimant hardship. Exhibit SW1 indicates that remittances were made many years after his resignation and after this case was instituted in 2020. So in other words, if he did not seek justice, his fate was uncertain as to whether he would have ever enjoyed his pension benefits, which every Nigerian worker is entitled to enjoy. The cost of this case is assessed at 750,000 naira. All sums hereby awarded in this judgment shall be paid within 30 days from the date of this judgment, failing which simple interest of 10% per annum shall apply. Judgment is entered accordingly. It is signed. So this is the judgment in the case between Mobolashi, Peters versus Commit Nigeria, and one other.
My Lord, we are most grateful for a well-considered judgment. And we pray that the good Lord continually grants, my Lord, wisdom, knowledge, and understanding. My Lord, Oliver Twist is asking for more. My Lord, we shall be asking for costs.
Were you listening to the judgment? The cost of this suit is assessed at 750,000 naira.
As God pleases, my Lord, due to network, I think I didn't get that. As God pleases. We are most grateful.
We are most grateful, my Lord, for the well-considered judgments. Thank you, my Lord.
Thank you very much, my Lord.
All right.